We also have our estate administration department. At some point we know we're all going to pass away, and there's a chance that we may end up being the trustee for somebody else as well. So we have the estate administration department to walk alongside the person who's there as the cleanup, I'll say, the person who has to administer things after you are gone. And then most of what we talk about today is how to avoid the court. We do not want you to wind up needing the court, whether it's during your lifetime or after you've passed away. However, we understand that sometimes that's going to happen no matter how much planning was done. And so we also have our estate litigation attorney, Elaine, to help step in if that becomes necessary. And then we couldn't do what we do as attorneys without our incredible staff. So we have one of the largest staffs for an estate planning firm. They allow us to serve our clients more efficiently, get questions answered in a more timely manner. And so when you work with one of our attorneys, you often have a team behind you as well. And then we have offices all over the state. Now, being here, most likely, you would be meeting with us in our San Jose office. But we're also able to work with you via Zoom or the phone. So if it's not as convenient to come in person, or if you're not actually physically located near one of these offices, again, we can then meet with you remotely as well. All right, with that, let's jump on in. So the first portion that I'm going to go through are the estate planning essentials. For those of you who do not have an estate plan, this is going to be a great crash course in what are the documents that I need? What do I need to have in place to make sure I'm protected, my estate is protected, and whoever I'm leaving things to, what do they need? If you have an estate plan already, this is also going to help cover what do I need to be aware of to keep up to date? Why are these documents important? Is there anything that has changed? So when we're talking estate planning, it's not just one document, it's not just two documents. It's a very comprehensive set of documents. You can't have just one, because the reality is we're not only dealing with what happens when you pass away, we're also looking to address what happens if I become incapacitated. What happens if I can't communicate my medical desires, or who's able to manage my finances? So again, it's not just after you've passed, it's that period of time where you're alive, but you're unwell. So one of those main documents is your Advanced Healthcare Directive. This is there so that in the event you can't communicate those medical decisions any longer, you have the person in place who has that authority. And we often recommend that you have alternates to that primary person. That way, if that primary becomes unable to serve, you already have in line who else would serve if that person can't. It's very important to note that your spouse doesn't even have an automatic right to make medical decisions for you. So if you are rushed into the hospital and your spouse doesn't have written authority, if you can't give verbal, they legally aren't even allowed to tell your spouse what room you're in. So it can cause catastrophic issues if you don't have this in writing. And if your spouse is not able to, again, it's important to have those alternates in place. The other thing with the healthcare directive is it's important to have one that's more comprehensive. So something that goes into, do you want to donate organs? Do you want to be on life support? Because answering those questions ahead of time not only gives you the dignity of control when you can't communicate, but it also takes a huge weight off of the person's shoulders who's in charge of having to make that decision. Because you already made it. They don't have to question, they don't have to feel guilty. All they need to do is carry out your wishes. And then the final point for this slide I want to note is if you have a healthcare directive, you need to make sure it was done after 2004. If you have a healthcare directive that was done before 2004, it is not going to be accepted because in 2004, HIPAA laws changed and there needs to be a specific statement in your directive or the doctors can't accept it. So again, 2004 for the healthcare is the key date to take note of. The one other thing on healthcare directives is if you have Kaiser. Kaiser started requesting or requiring that there be specific language of when your directive becomes effective. And so, if you, one second, back on, no. Okay, here we go, no. I'm gonna try to yell while this gets figured out. Can you guys hear me in the back or no? Yeah? Okay. I'm going to try to project as much as possible and keep trying to test this as much as possible. So for Kaiser patients, if you have Kaiser, you need to make sure that you come in and see us because there is specific language that we can add that's an addendum to your healthcare directive. Essentially, it's a very quick statement of, again, when should this thing be in effect? If you don't have Kaiser, disregard this component. If you have Kaiser, come in and see us. All right, let's see. No. All right. I might just have to yell the rest of the time. All right. Okay. I'm going to move forward a little bit, that way I'm not yelling quite as much. The next document that's extremely important to have in place is your durable or financial power of attorney. This financial power of attorney is there so that, again, if you can no longer communicate, this is specific to finances. At that point, what you need to have in place is, if I can't manage finances, who is actually able to? Again, your spouse may be on a decent number of your accounts, but they won't be on things like retirement. So if you can't physically go and manage that retirement account, your spouse is only often named as a beneficiary, which means they can't manage that money. But it may be money that's very necessary to help take care of you. So you need a power of attorney that gives them that authority to go and manage those accounts. And again, if your spouse can't, having alternates named is extremely important. Now, the date to keep note of for your financial power of attorney. It needs to have been done in the last 5 years. If you have a financial power of attorney that is older than 5 years, banks are now rejecting them. The reason is that they have decided it's one of the ways to crack down on financial fraud and elder abuse. They're saying if it's more than 5 years old, it's stale. And so unfortunately, that has led to a lot of them being rejected when somebody really needs it. And that is not the time you want to find out that your document won't be accepted. So that 5-year component is extremely important. If you're not sure when yours was done, feel free to bring it into us. We also often have the electronic. We can take a look at it and let you know when was it signed and do you need to have it updated at this point. Now, one of the other issues with not having these documents in place is if you're incapacitated and you don't have those two or they're not valid, unfortunately, what that requires is that we go to court and get what's called a conservatorship. It's essentially where the court is saying you didn't have something in place properly or at all that says who can take care of you medically and who can take care of your finances. And so without those documents, the court gets to decide who's going to take care of you medically and who's going to take care of you financially. A couple of issues with that. One is anytime court is involved is more expensive. Second thing is, with a conservatorship, it means you're often in a very vulnerable state because you're incapacitated. It means you may not be able to get doctor's appointments scheduled, prescriptions set up, your finances sit there essentially idle until someone is given that permission. So going through a conservatorship is something that is easily avoided with those two documents and is a nightmare to go through if you don't have them. So if you take nothing else away from today, make sure you have that healthcare directive that's more recent than 2004, and you have that financial power of attorney that's been updated in the last 5 years. So then the next question we look to address is, do you need a will or do you need a trust? Now, in California, wills are very restrictive. Most people have too much, according to California, to qualify for a will. So in California, if you have less than about $209,000, interesting. If you have less than about $209,000, then a will is something that may be applicable to you. But if you have more than that 209 and only had a will, when you pass away, the court would again get involved because they're going to say your will is too simple for the complexity of your estate. And so when they get involved, That is in the form of what is called probate court. So probate court is essentially where, the court says your will was too simple and your estate was too complex. So they get to decide who's going to be your executor, or if you did have a will, they can confirm or deny who would be your executor. They get to decide where the money's going to go and who those beneficiaries are. It's essentially putting a lot of control in the court's hands. And it's an entity that obviously does not know you. And so again, for a lot of people, a will is not going to be the vehicle that we want you set up in because it's not enough to fully protect you. Oh, there we go. All right. Now I can stop yelling, sorry. All right, thank you. So again, when we're dealing with court, another one of the issues is cost. So probate sets what the fees are, which means we don't actually have that much control over what probate is going to cost the estate. If you are curious what probate would cost you specifically, on Kopenberger.com we have a resources tab that has a probate calculator. One of the things to note is that when we're looking at the probate costs, it's based on the gross value of your estate. What that means is if you have a home that you could sell for $1.5 million, they do not care what the equity is in that property. Your equity could be $100,000. They're still going to put the probate fees on the full $1.5 million. So you can imagine with probate how much that can end up depleting your estate. You could have to have a mortgage paid off. You have these attorney's fees that again are actually set by the court. If your executor/administrator takes their fee, you can see how that then eats into the estate. Any other debts would likely have to be paid off. So unfortunately, again, when we're dealing with probate, there are a lot of ways that it eats into what would have otherwise been avoided and gone to the beneficiaries. So that is where, for a lot of our clients, we put them into what is called a living trust. Your living trust is essentially the more complex document that answers all of the questions about your estate that the court said your will did not. So your trust gets to say who's going to take over management when you no longer can. It's going to say who those beneficiaries are and how those beneficiaries will inherit. Because just in a situation where you have 3 kids, it doesn't necessarily mean you want those 3 kids to inherit the same amount or in the same way or at the same time. So we get to allow you at that point to build this contract however you want and however is going to fit your family. So rather than the court having that control, you have that control even after you have passed away. So again, a huge component is avoiding probate. You get the control, your family maintains the control, we don't have to go through court. Another big piece though is it allows for tax planning. A decent chunk of what we'll talk about in one of the later sections is different issues that have to do with taxes. That can be property taxes, this can be capital gains taxes. Whether we like it or not, taxes apply to our estates. And there are things that you can do in your trust to avoid the unnecessary taxes. And that is something we at least want you to be aware of, and then you can choose what's going to be applicable and not. But one of the issues with setting up a trust is often who's going to manage. In some cases, it's very cut and dry. Maybe it's, okay, my spouse will be the primary, and then I've got those 3 kids, and it's going to go 1, 2, 3. Well, what happens if either you don't have children, or you don't actually want your kids to be the ones to manage for you? That's where we can help brainstorm for clients. One of the things that we hear a lot of times is people don't start their estate planning because they get stuck on the question of who's going to manage if I no longer can. So you can have what is called a directed trustee. This is a person who could work with somebody else, but it's the person who would deal with the management of money. Versus your other trustee who would work with them could be the person who deals with your stuff. It's cleaning up the house and dealing with that side of it. Maybe you just flat want someone who will take care of it start to finish, both for the stuff and the money. That's where we then look at professional or private fiduciaries. But all of this is to say that if you are stuck on a question, if you're not sure you're ready to start your estate planning because there's something you don't have an answer to yet, come in and speak with us. Because again, our job is to help brainstorm what are some alternates or alternative ideas that you may not have thought about. Now, one of the other issues with the trust is it only fully protects what it owns. So one of the things when you set up a trust that you should be instructed to do is to transfer certain assets into the name of the trust. Generally speaking, that's going to be your checking, savings, non-retirement investments, and pieces of real property. Those are the 4 big categories that we recommend.
Can you repeat those?
Repeat them, yes. Checking accounts, savings accounts, non-retirement investment accounts or brokerage accounts, and then real property. Those are the things that should be under the name of your trust. Now, there are some exceptions to that. Everybody has different circumstances, but again, those are the main categories that should be. If, for example, you have a bank account, let's say it's got $300,000 in it, it's in your name alone, there's no beneficiaries on it, and you pass away. Ordinarily, the court could control that asset when you pass away, even though you have a trust. But we do create what's called a pour-over will that complements or supplements your trust. Essentially, what this will's job is to do is to say, court, you still don't get to control that $300,000 account. You need to give it back to my trust. So it does require us to go to the court, but it at least keeps it out of the full court proceeding, rather than, again, the court getting to control the whole process. If you have questions on how do I make sure my assets are under the trust, what document do I need to do, have I done this correctly, please feel free to take advantage of those consultations available so that we can go through that.
Victoria, quick question.
Yes.
So you, previous slide showed cost of probate.
Yes.
How does this cost of probate for a pour-over will compare?
It's significant. The cost of probate, if it's dealing with the pour-over will, is significantly less because it's, yes, needing court involvement to have them confirm the asset can go back to your trust, but it's keeping it from the full process. So normally it's an hourly attorney rate at that point.
So it's not the entire estate, it's just
Correct.
that portion
It's
that's
that asset.
being poured over.
Exactly.
Okay.
Exactly. Now, one of the other things people often overlook at this point are their digital assets. So for a lot of people now, we have things on our smartphone. That could be photos, that can be contacts, that can be our banking information. There's a lot now that we carry around in our pocket that is no longer in physical form. And so one of the things that has happened is people pass away and those assets are lost because somebody doesn't have your password and somebody is not put as what is called a legacy contact. One of the things to note for your smartphones, especially for Apple and Android, actually I believe Samsung, I think all of them at this point do, allow what is called a legacy contact. This is essentially a person who's able to access your account after you've passed away, even if they don't have your password. Now you can truly just Google how to set a legacy contact on whichever phone, okay? On whichever phone you have. David! A legacy contact on whichever phone that you have. And again, it's then the person that's able to access those things when you're gone. One of the biggest things when my grandma passed is we used her phone for the funeral invite. It was allowing people to know that she had passed away. Because she wasn't keeping up to date the physical copy of her Rolodex that she had anymore, she kept people in her phone. For me, most of my photos are not printed out at this point. They're on my phone. And those are things that I would want someone to have access to after I'm gone, because those are assets that end up lost. So again, when you're thinking about your planning, it's not just about the money. The money is a big piece of it, but what about the other stuff? Now, another one is cryptocurrency. If you have cryptocurrency, you may already be aware of this, but for most cryptocurrencies, if somebody does not have the key, the code, the chain, whatever it is that would give them access, if you pass away without that being somewhere for someone to find, that asset is lost. So it's something very important to make sure. You probably don't want someone to have it during your lifetime, but it is very important. Thank you. It is very important to make sure that it could be in your safe, it could be somewhere protected, but that someone can't have access to. Because again, it's one of those assets that if you pass without that, it is gone. Then another thing that we think about is, what about all the other non-monetarily valued things? It's the stuff that fills our homes, it's our recipes, it's those things that, again, don't necessarily have a monetary value, but may have an emotional value. A lot of people tell us, I've already asked my kids and they don't want anything. And you've probably, if you've been to a seminar, heard me say this many times. That is very true until the person has passed away. And then all of a sudden, the stuff becomes the tangible thing to hold on to. And that is when the emotional value kicks in. So one of the things in your Koppenbarger Trust that you have the ability to do is to use what is called a memorandum. What this is it's a handwritten letter where you can say what the item is, who it goes to, and then you sign and date it. That essentially allows you then to leave specific items to specific people. Even if your kids are telling you, again, that they don't want anything, I very strongly encourage, if there's something with family history or you think they would like it, the worst case scenario is you leave it to them and they then say, no, I really didn't want it. But in so many cases, those items that are left end up again having such a huge value on the emotional side. Yes?
Is that also known as the assignment document?
The assignment is a little bit different. The assignment that we have in your trust is an overarching statement that all of your stuff belongs to the trust so that the court can't touch your stuff. The memorandum goes beyond that to say specific items can go to specific people. So they're a little bit different. But if you do have any questions on how to use these memorandums, we do have a how-to. Happy to either email it or we have physical copies in the San Jose office. But again, it's essentially allowing those potentially emotional items to be given to specific people if you think that that is something that your family would care about. Now, one of the things I really want to emphasize, the DIY estate plans, doing it yourself amendments, things of that nature at home. I cannot caution you enough, especially for those of you who have not potentially started estate planning. It can be very enticing when you see online the free plans or those $300 packages. It seems very, again, enticing because they're cheap. But cheap is cheap, and there is a reason that they do not cost a lot. For one, you may not be working with an attorney, which means if something is done wrong, there is no one to hold accountable because only attorneys can be held accountable for legal malpractice. And as much as I never want to be sued, the reality is if somebody makes a mistake, you want someone to be held accountable. Because some of the mistakes that we have seen with these DIY plans are catastrophic and cost the family a lot of money. The other issue is for things like funding. What assets go into my trust? Well, if you don't have somebody explaining that step, again, that can be a huge miss that costs the family a lot of money after you are gone. Doing things yourself, and when I'm talking about that, it's amending your trust. We have people who will start to write over their original documents, they cross a person out, they handwrite a person in. This can do a few things. One, it can just flat lead to confusion, which can lead to the court. Two, it may invalidate that section, which again can lead to the court. And three, if it's bad enough, it can even invalidate the full document, which again could lead to the court. So while estate planning done correctly is not going to be as cheap as what you would find online, it ultimately saves you and the family money in the long run. So if you have questions on what am I allowed to do or not do, if you're worried about doing a DIY plan and you're thinking about what are the pros and cons, we are happy to walk through those with you. But I would very much caution, again, when you see a price tag that seems too good to be true, so to speak, it's probably because it is. So it is extremely important when you're looking at estate planning to make sure it is done correctly. California has very complicated rules, and little issues and little misses can have a fundamental difference down the line. So again, you want to make sure things are done correctly. All right, so those were the basics. That was the foundation. Now, one of the other pieces is when we're looking at estate planning, it's on a life cycle. So what that means is when you first set your estate planning up, it doesn't necessarily mean that that's going to be it forever. A lot of times when you first do a plan, it's going to look very different 10, 20, 30 years down the line. Because maybe you were single when you first did your plan, or you were married and now aren't, or maybe you didn't have kids or they were minors. There's so many different ways that your estate plan may need to adapt and be changed to keep up with what your life is doing. Again, do you have children that are now adults? Are your beneficiaries still the same? Are you planning on moving? That is becoming more and more common, especially for people leaving the state. Before you move, so if you are planning on moving out of the state, it is extremely important to make sure that you're doing things correctly as you're changing your assets. So you may be selling a home here and buying one in a different state. You may be closing bank accounts and opening new ones. It's extremely important to make sure that as you're changing your assets, you're ensuring that whoever you're buying a house with or opening a bank account with knows that you have a trust, so that they will continue to put assets under the existing trust. As you move, maybe you're moving away from the person who is your trustee at the time. Maybe you're moving closer to a different child and it makes more sense for them now to be the successor trustee. There are different reasons as you move that, again, your estate plan should at least be looked at to make sure that as those changes are happening, the plan still makes the most sense. What if you got married? Or inversely, what if you got divorced? Anytime there's a relationship change, we want to make sure we look at your estate plan. Just because you got married doesn't necessarily mean you want that spouse to be included in your estate plan. Maybe it's a blended family situation, and so things need to be kept more separate. What happens if you get divorced? Well, especially in the case of a divorce, for things like your power of attorney for finance and medical, you probably don't want that ex-spouse making your medical decisions or managing your finances, I would assume. So it's, again, extremely important to make sure that these documents get updated to account for who's now in your life or who has left your life. If you have gotten married, there are different protection options that are also available to married couples. One of those is called an AB trust. What that trust is essentially going to do is when one of you passes away, half of the trust becomes irrevocable. What that does is if the survivor remarries or the survivor decides to change their half of the trust, they can't change what happens to your half. So they can't take somebody out or put somebody in that you wouldn't have wanted. So again, as a married couple, you may have different choices to go through than you did as a single individual. So these are, again, reasons that when life circumstances change, at least come and speak with us. You may not need to change anything, but it's at least good for you to know that you don't have to, rather than assuming you don't need to and something being missed. Now, what happens when your kids become adults? Well, when kids become adults, they may have their own what we call creditors. What that means is when they receive an inheritance, who potentially is going to want to go after it? What happens if they go through a divorce? Or they're in a car accident that was completely their fault? There are protections that are available for their inheritance that insulate it from these outside financial predators. Their own estate may be subject to whatever their liabilities are, but the inheritance that you leave to them does not have to be. So again, this is one of the options that we can go through and see, does this make the most sense for your family or not? What happens if you have a special needs child or beneficiary? Now, one of the things I want to pause, you'll see this QR code. What that means is we have done a specific webinar on this topic, because for things like special needs beneficiaries, they're not applicable quite as much across the board. But if it is something that you want more information on, feel free to scan the QR code. It should be in your handout as well, and that will take you to that specific webinar. But with special needs beneficiaries that are on government benefits, a lot of people assume that they cannot leave an inheritance because the person will lose their government benefits, which is true without proper planning. But you're able to set up what is called a special needs or supplemental needs trust, where you can leave an inheritance that will be managed by somebody else that can then supplement what the government benefits do not cover. So rather than them either not receiving inheritance or receiving one and losing benefits, you again can now supplement those benefits without costing them. So if you do have questions on this, again, either use the QR code or happy to discuss it in a consultation. But I mentioned earlier that one of our departments is advanced planning. So we do a lot of planning that goes above and beyond the basics of revocable plans. If you have more advanced questions, you have a more specific question, and you're not sure how to plan for it, still come in and speak with us. Because again, we do a lot of planning that goes above and beyond the basic components. So if you are concerned about, again, your rental properties, maybe you have animals that are going to outlive you. If you have a tortoise or a parrot, they may outlive you. You want to make sure you plan for them. What if you have livestock? That's not something that someone with an apartment can probably assume. These are things that, again, if you have more specific questions or specific needs, we can still help address. But I mentioned earlier about the DIY changes. I really do want to emphasize, you need to make sure if you have changes that you want that they are done correctly. An email to us isn't enough. We need to make sure that changes are actually notarized and put into effect. Writing all over your documents, I already talked about the risk there. So if you do have changes, there are certain things you're able to do at home, but it's a very, very limited component. So if you do have questions on this, it is always better to ask and us instruct you correctly than to guess and us find out it was done improperly at a time when we don't want to be finding that out. So those were the life changes that often flag needing to come in. What about legal changes? So there have been a lot. I really cannot emphasize how many legal changes there have been over the last 6 years. If you have not seen us since 2020, odds are these are going to come potentially as a bit of a surprise. If you've been to the seminars, some of these you probably have already heard about. But what we often find is when these legal changes happen, they're not very well publicized by the state. And so one of the things we want to make sure that you're aware of is how these may affect you, but also what planning options you have to help protect you from the consequences. The first one is Proposition 19. So this drastically changed when children inherit property, what is able to maintain your property tax base. The only property at this point that is able to maintain your property tax base is your primary residence. But your children often also have to claim it as their primary residence. So it's not just that the primary transfers, it's that the child also has to live in it as their residence. Now this can be an issue when you have more than one child. So let's go back to a scenario where you have 3 kids. Let's say your trust is currently written that those 3 children will inherit your property equally, and distributions after you've passed are made and the property goes to them equally. And child A says, can I buy you guys out? I'd really like to live in it. Are you good with that? And they say, yeah, great, sure. So now there's what's called a child-to-child transfer because the kids are buying each other out, which in that scenario would mean that 2/3 of the property are reassessed. Instead, what could have happened is we could have put language in your trust that before distributions are made, that the kids could have chosen to have what's called the right of first refusal, where the kid you think is most likely could pre-decide that the other 2 will get cash and they will get the property. What that means is it still qualifies as a parent-to-child transfer because it happened before the distribution was made, which again allows them to then preserve the property tax base and not have that 2/3 reassessment. So if you have multiple children and you're worried about trying to preserve the property taxes, that is one of the ways that we can do it. The other thing to note is if you're planning to buy a new piece of property, you can do what is called LLC protection. Now this is only for new property, not currently owned property. So if you already own it, unfortunately, this is not a viable option. But if you're going to buy property, I would very much recommend speaking with Catherine, who you'll hear from in a minute, so that you can talk about is an LLC the right option for you. Because if you have an LLC and you pass away, The LLC ownership transfers, but the property actually doesn't. So again, it's one of the ways then to preserve the property taxes. Another huge component that has changed of late is Medi-Cal. Medi-Cal has gone through a lot of changes. Last year they decided that in order to qualify for Medi-Cal, that they would be looking at your income. That was a huge change because prior they would look at your assets. So last year they decided, nope, we're looking at income. Well, then they decided, nope, we're not doing that, we're going back to assets. So with the assets, what that essentially means is, if you have more than, jumping way ahead, if you have more than $130,000, Medi-Cal is going to say that you cannot qualify for those benefits. However, one of the things to note is with proper planning, I'm so sorry, I need to grab a sip of water. Catherine, can I hand it over to you for a second? Okay. I'm actually going to fast forward us because she just needs to take a couple minutes, but then we'll go back to this content and she'll follow up. There are some really interesting legal changes in just let's see if I can get to the right slide ahead. If you can bear with us. So we are looking at, it's at least going to be several pages, so I'll give you just a moment to flip forward. This is the section that we're going to be looking at for just a few minutes until she comes back. So the second part of legal changes, and let me start by introducing myself. There are familiar faces in the room, certainly I've met quite a number of you, but I'm Catherine Grout. I'm an attorney here at Cope & Barker, and I primarily work in our business tax and advanced planning department. I focus most personally heavily on business, but I also work with our tax attorney and our advanced planning attorney on all of that scope. So I'm going to be discussing some of the services that Cope & Barker can help you with under that entire department. Has everyone generally found, or does anyone need more direction to get to navigate to this section? Are we generally good? Okay. So I'm just going to go through a couple of legal changes, and she was talking about Medi-Cal. We're going to fast forward a little bit to the estate tax exemption, which varies every year and varies by administration too. Right now, and if you've been to any of our conferences or any of our seminars recently, the estate tax exemption is very high. What this means is if your estate is less than 15 million, you generally don't need to worry about being taxed that estate tax. If it's over that, then we definitely want you to come in at a minimum. If you're just a little bit over that, at a minimum, come in for your revocable living trust. We can make it into a split AB trust and then mitigate some of your estate tax liability. If you're single and looking at this or close to this threshold, definitely come in, because once we get to even higher than this, we'll need to examine some advanced planning options. How can we shift some of those assets away from your taxable estate, perhaps into an irrevocable trust that then won't be counted against your entire taxable estate? So part of the services that we provide in my department, that advanced planning section, that focuses on what vehicles, what irrevocable trusts can we utilize based on what your goals are, your personal goals, where you want that money to be going, who you want it to be going to, and how, on what schedules. There's plenty of different vehicles that we can look at to accomplish those goals. But that's only for if we're looking at an estate that is above 15 million or even double that for a married couple, some of those advanced planning options. Now, I also want to discuss the annual gift tax exclusion. So this adjusts a little bit each year with inflation. Right now it's at about $18,000. So, and with the cost of things these days, honestly, we can reach this pretty quickly. Because let's say
You want to support your child or a family member by giving them a lump sum either to pay for student loans, to pay for college, to pay for maybe a car, because cars cost way more than this now. If you are gifting to anyone in excess of this amount, that's okay, but you'll need to be careful and make sure that you're coming to us with help if you need to file a gift tax exemption or a gift tax return. And that excess, so anything below that threshold, that 18,000, that IRS generally doesn't care about it, right? But if we're reporting on a gift tax return, and it's over that, then that's going to count against your lifetime exemption, the other number that we're looking at. So just something, if you plan to gift more than this in a year or anywhere near this in a year, please come to us. Let us help you kind of navigate how best to accomplish that and help you with a return if you need to file one. Okay, one other concept that I want to talk about is this portability. So we talked a little bit about the estate tax exemption. Nice and high right now, but fluctuates with administrations, changes a lot over time. It is historically high for what it has been recently. And with a new administration, we could see it drop very low. So we want to keep all of our options available to us. And one of those tools that we can use is portability. So if you are part of a marital unit, your spouse passes away, and this estate tax exemption is nice and high still, that portion of your spouse's unused exemption, so let's say they don't need that exemption because of the size of your estate. There are, 4 million remaining in that exemption that is unused. You've fallen below the threshold. You can actually port over, as long as you file in time, port over that 4 million to then your estate tax exemption, meaning you get yours, whatever it may be at the time that you pass away, plus that 4 million that you ported over flat, okay? So if nice and high, your spouse passes away, you poured over whatever they didn't use, and then it plummets down to 1 million, right? Your estate is worth 3 million when you pass away, but you've ported over that additional 4 million, you're covered. So something that you want to be mindful, whenever you have incapacity or your spouse passes away, please come see us for an administration appointment. Even if you don't think that you need to do something, there are a lot of boxes and things a lot of boxes to check, a lot of things to consider. So please come in and have an appointment with our trust administration team. Okay. A couple more general notes, especially since I represent more of the business side, and a lot of the businesses that I deal with are actually rental property businesses. I know that we're streaming, so we have some people online. We also post this, some people watch it afterwards. So I do want to cover all the topics today, but I also would like to get a sense of people in the room too. Does anyone have a second rental property, second home that they rent out? A couple of individuals, thank you for raising your hands. And then I'm gonna go a little bit more broad. Is anyone a consultant or an independent contractor business? Maybe they've created an LLC for their services. A couple of people. Anyone, small business owner or part owner in a small business? Raise your hands nice and high. Not too, okay. Not too many, so we're probably not going to talk about any of the employment law changes. Usually at these seminars, I don't get too many people that this relates to, but I do just want to make a quick plug. So every year in the state of California, there's plenty of employment law changes. If you have any questions, whether you're an employee and have some concerns, we have a litigation department that can probably help out. Or if you are an employer or looking to be an employer because you're starting a new business, and have some questions about some of the legality of any business practices, we can handle those services for you. But another point that I want to make, or another thing I want to touch on specifically, is tenant law. So employment law, that's a legal update that we see plenty of changes each year in the state of California. Very employee-friendly state that we live in. Yep.
Do you have a tab on your website that goes over all the new laws?
So we have a couple of things. We do have a general tab for employment stuff, and we regularly post new blog articles. We actually have one coming up soon about employment changes for this year. So just keep an eye out for that. We try and post and kind of blast that out on our social media, LinkedIn, if you follow us anywhere. But no, I don't have a specific list. If you do have specific questions, please let me know. I'm happy to have a direct discussion with you. But that's a nice plug for some of our articles and resources that are available on our website. I also then want to get back to, so tenant law also changes. California is a very tenant-friendly state. Not so much landlord-friendly with their laws and updates. If you do have tenants, if you have a second home that you're renting out, please keep in mind that there are new obligations for you as a landlord every single year. This one, a couple of quick highlights of some of the changes for this. We saw that fridges and stoves are now included in the habitability requirements. So let's say you have an ADU with sort of a modified kitchen, maybe you don't have full kitchen. If you want to qualify for habitability, and you need to as a landlord, you'll need a working fridge and stove. That's going to be a requirement. The bigger change happened last year, or the change that I think is most relevant to landlords, is before and after photos. So I'd like to plug this again. Take before photos before your tenants move in and after, if you want to claim any of that security deposit, and then also for any work done. So if you're having something serviced in the apartment, if you're having any work performed, you'll want to take before and after photos, whatever it may be. Okay?
Could you comment on the Social Security benefits being a hardship?
Yeah, so just when you're looking at an eviction and trying to evict someone, if they make a claim that they had a delay in receiving their Social Security benefits, if that's the reason, then they get a pass, essentially. You won't be able to make that claim. That's a full defense, is delay in Social Security benefits. These aren't the only changes, but these were some of the most applicable to most people, biggest ticket items. So if you need any help reviewing your tenant agreements, if you need new lease terms, if you need to renegotiate anything, that's all stuff that we can help you with. If you're looking at what are my notice requirements in this state and specifically my county, because they may have different requirements, for any type of notice, whether it's eviction or not, or move out or not, or termination of the lease or not. All of those types of things we can definitely help counsel you with. Okay. I'm going to, Zach, do you want to jump into your section? Or do you want me to keep going on to my next? I'll keep going on to my next section, and then we'll go to Zach just because I'm up here and it'll be easier. So one thing, now we're continuing to progress. There's no jump ahead, we're just going to the next section. So I have a couple more points to talk about that I've already sort of started to highlight in the earlier discussion with legal changes. And these are just in that advanced planning and business planning segment of Copa Barker's legal services. So these are kind of some of what I already talked about. So our advanced planning department, we have an amazing, relatively new to the firm attorney, Kevin Vandenbroek, who joined us last year. He's a very seasoned attorney and is the lead of our advanced planning department. If you had, and it's not just estate tax exposure like I discussed earlier, If you also have charitable goals, or if you have certain types of assets, let's say highly appreciable assets, stocks, something that you need to figure out, there's a big tax liability associated with it, or if you have any liquidity events, any interesting assets, any number of these could be reasons why we want to get you in front of Kevin and possibly myself to discuss some of the advanced planning options that would be available to you. Now, I just highlight this because there are so many potential vehicles that we could utilize depending on what your goals are. So for the estate tax exposure, like I was mentioning before, we're trying to shift some of those assets so that they're outside of your taxable estate. And there's many, many different irrevocable trusts and other vehicles to do that with. There's also a lot of charitable trust vehicles, and depending on how you want to give to charity, there are a lot of different options. So, for example, charitable remainder trusts are trusts that basically they pay out first to you or your loved ones, first to your family, and then the remainder essentially goes to charity. Charitable lead trusts that you're paying to charity right away. So it's kind of in the name. And then there's plenty of other options if you're looking for more involvement. If you're looking to start your own church, if you're looking to start a nonprofit, that's all something that our business team can help you with as well. So lots of charitable options depending on what your goals are. Then one other thing that I want to touch on, a couple other things that I want to touch on. So we already sort of started to talk about this. If you have rental property, I know there were a number of hands in the room, and there's probably a number watching and who will watch the recording. If you have rental property and you don't have that rental property in a limited liability company yet, please come see me. An LLC or limited liability company is an amazing vehicle to avoid personal and shield your personal assets, shielding you and your other assets from the liabilities associated with that rental property. And we could think of any number of liabilities associated with it. It could be a slip and fall claim, any incident that happens on the property, or something with the character or nature of the property. There's so many potential liabilities, and these days a lot of those legal claims can be in the millions and exponentially just increase from there. This is in conjunction with, alongside, an umbrella policy. If you have an umbrella policy for your rental property right now, that is great. That doesn't mean that you shouldn't put that property in an LLC. I usually recommend both. This is a discussion that I can have with you on a one-on-one, but almost always, unless there's maybe some exception here, almost always if you have a rental property, I highly recommend putting it into a limited liability company. It's a low investment. It's a low initial investment, very, very minimal ongoing investment, and almost comprehensive personal liability shield, as long as you're running that limited liability company, that LLC, appropriately. And then I also plugged this just a few minutes ago. So if you have any interesting assets, I'll call them interesting, highly appreciable assets, something that you're not sure what to do with, but know there's a lot of tax liability with them, please come and see our attorney and any of our tax advisors. We're happy to discuss some of the options on how to mitigate some of that tax liability. Yeah, go ahead.
I have a question that for the LLC, liability business.
Yeah.
If you have like several rental properties, you can buy one LLC instead of like each LLC.
Yeah, so I'll repeat the question a little bit. She had asked if they have multiple rental properties, do you combine them into one LLC or put them into their own LLC, or how do you break it up? And I get this question a lot, and we find there's not one right answer. I will say that each LLC, the most risk conservative approach is to put each property generally into its own LLC. However, you may not want that much management. Think about it this way, based on your personal situation, it will vary. But every single LLC, any assets that you put into one LLC, they exist together, sort of corralled. So if there are two properties in one LLC and something happens on one property, both properties are exposed. They're contained in the same business unit, okay? So they tie liability together depending on what is sitting in that LLC. So if there's a very risky property or something associated with it that's very, there's a high liability around it, you might want to definitely isolate that one. If there are some that are lower risk or lower, they're just lower property value. There's just less risk and liability associated with them for some various reason. You might put them together. Typically, I recommend one LLC per property, but it depends. And so every situation is going to be unique, and your personal risk preference is going to, or your risk tolerance is going to be unique as well. So that's a conversation I usually have in a one-on-one basis with clients.
The FLP with many different properties and it's still as good as the LLC.
LLP?
FLP.
Family liability, yeah. So the limited liability company is going to be unique in this nature of how much it will shield. And FLP, I won't get too far into this, but and we do have some content available because I don't want to get too far off topic. But that the FLP, think about it this way: there are some owners of an FLP that have complete exposure to liability, the general partners, or near complete exposure to liability. And then there are limited partners. So in a family limited partnership, FLP, there are general partners and limited partners. There are some people that have protections from liabilities and some that don't. So it's not as comprehensive of a shield as an LLC, but it may be something that works depending on the situation. Typically, I recommend an LLC or a subsidiary LLC, an FLP that may own an LLC interest. Okay. So all of that, I'm skipping. Well, I'm not really skipping. We've kind of talked a bit about this. So we can help you structure business plans, any of these assets that you want to structure. We'll work with you on what works best for you. Which entity you're setting up. Are you setting up a limited partnership? Are you setting up an LLC? Are you setting up both? Are you setting up a nonprofit? We'll work with you. And then there's a number of further services that we can counsel you on if you are an operational, but if you're a new venture, you actually have services that you're providing. You have branding, trademark, intellectual property. That's all stuff that we can actually help you with at Cope & Barger. We do file trademarks, copyrights, and then help you with risk mitigation for any confidential information that your business may have. Like I already mentioned, employee and HR, materials, policies, any help with that, we can assist. At this point though, I'm definitely going to jump now backwards. So now we'll go to lifestyle, and I'll have Zach come up. So if you're in your booklets, we are going to be, I'll put this up in just one moment. I want to make sure we're following along. So here's what we're looking at, dark green now, not light green anymore. And Zachary, if you feel free to come up. But I'll pass it over to Zach, and he'll talk.
Thank you, Catherine. Morning, everybody. I'll let you guys take a minute to get to the page. Thank you guys for your patience in jumping out of order. The seminars at Cope & Barger keep you on your toes because you're literally going through estate planning, but I like to think they're the most entertaining lawyers in show business, so this is pretty impressive stuff. For those of you, yes?
Can't see you because you're standing right in front of the window.
Stick away.
Thank you. Okay.
Thank you.
Is this better?
Yes, I can see you.
And you guys can hear me?
Yes.
Okay, I like this. Now, because you can see and hear me, everything I say is going to be great. Yeah?
Okay.
This is going to be awesome. A little background about Lifestyle Financial for those of you guys who don't know us. Many years ago, Lloyd Kopenbarger did one of the greatest things ever and married Laura Kopenbarger, who founded Lifestyle Financial. And they became an original power couple in law and finance, trying to help people when it made sense. A few years later, Laura has since retired from Lifestyle Financial. Lloyd is still there. I don't think he's ever going to leave Kopenbarger, and they'll have to drag him out of the office. I think they have a couple of times. He's just very strong. And Laura's grandson, Charles Sosa, and myself are now the advisors at Lifestyle Financial. We try to carry on the same legacy, families helping families. For those of you who don't know, we like to be very transparent at Lifestyle and at Kopenbarger. Victoria Raymond is my wife. The best thing I ever did in my life is marry her. Some of you have had the pleasure of also meeting my daughter, Emma. She is wonderful. Come to me by the booth. I will talk to you about many stories about work, but I'll also weave in stories about Emma and Victoria, whether or not they sign a waiver. Not a waiver, so I don't have to worry about that. A little background about me is I came from a small firm called Merrill Lynch. Show of hands, who's ever heard of that firm? Yeah, I have stories if you want. Again, back at the booth, I'll give some stories about Merrill Lynch too. A wonderful firm to understand how the markets work. Make no mistake, there are many great advisors and many wirehouses, independent wirehouses. I do not believe in speaking ill of my peers because what you say is your reputation, that is your currency in this business. Merrill Lynch gave me the training. I was able to take that and partner with Charles Sosa to take that big firm mindset into a family office to help families. It's a lot of fun. I also am not run by a bank. Merrill Lynch is owned by a company called Bank of America. I will just not say anything about Bank of America. I bank there. But I do enjoy not being run by a bank. So let's get into this. What do we do? Show of hands. Do people here have more than $5 to their name? I appreciate a few people who raise their hands. That means, yes, yeah, I agree with that. That means that I will speak with you because generally speaking, I think more than $5 is money that requires a little bit of planning. There are people who have considerably more. There are people who have retirement assets, non-retirement assets, all stock, all bonds, all alternative investments. There are so many things called alternative investments. I will run out of time explaining what they are. We can talk about them though at another time. Basically, if it touches money, your wealth managers, financial advisors. My mentor was a stockbroker, so I usually like that moniker as a badge of honor. I'm a stockbroker. I'm a stock junkie by trade. Thank you. I'm going to go this way then, but not too far. We should be trained and knowledgeable enough to be able to have conversations with all of you about these individual components that touch the monies in your life, because that's how you build wealth management for a life cycle. You just heard from wonderful attorneys, arguably I think the best attorney, my wife, about creating 4 walls of an estate plan document, LLCs, fiscal entities to help protect your estate. But you need the financial components to work to do the things that you're going to put a lot of resources into creating these estate planning documents for. Make sense? So again, a couple of the things that we like to talk about at the office. Show of hands. So has anybody heard about anything in, I don't know, the Strait of Hormuz lately? Let's say Iran. I think TSA is looking for new hires, or maybe anybody wants to shell out some dollars to fund them. We have midterms later this year. Any of these things ring a bell for anybody? So we're talking about all of this because it does impact finances. Here's a general question. How many declarations of war has the President of the United States actually gone to Congress to ask for? Not zero, but that's a good first answer. I'll give you a hint. The last one was World War II. It's actually 5. Now, it's a show of how engagements or conflicts happen, not always documented normally through history, but still the same market impacts, because what happens around the world or engagements does impact the stock market, so we have to keep up to date on that. I am not by trade, I'm not a military tactician or historian, but it's important to understand that because there is a playbook for investing in volatile cycles, like everything that goes around what's happening in the Middle East. There's still an engagement in the Ukraine, and just in case anybody forgot, there is a not-so-friendly relationship with the other superpower in the world, China, that we are still very actively trying to understand how to invest in the future with that. Now, with all that said, that might seem like a cautionary tale to not invest. But why should you invest? Well, markets don't ring bells at tops or bottoms. There's no perfect timing for any sort of beginning point of an investment cycle, the perfect exit strategy. There's a discipline where you have to have a plan that's accustomed to whatever your specific investment life cycle is, where you are in life, how much risk and return you're comfortable going into the markets for. What does this mean for your lifestyle? What do you want to do with these funds? Do you have show of hands, how many people here have grandchildren and they would like to help them at college? Because college will be $500,000 per year and they're going to be in school for 8 years because of graduate school. This is a very large ticket item. Or maybe you know that as you live longer, the cost of medical care gets more expensive. It vastly outpaces inflation. Or maybe there will be something in the future that Social Security might not be there in the same style it is now. You want to plan for it today and be able to absorb these volatile markets and still not have to worry about the plan because you have a team working around the clock to make sure that this is also part of the plan. Does that make sense? The other thing that I like to tell people is it's not just these things that get page 1 of the news that are moving markets. I usually like to do a Q&A, so if there's time I might offer some questions here, or please come visit me in the booth for more questions. I very much like to talk to people. The other thing that I would say that is undeniable, as much as I stand in front of you today, is that we are very much in an innovation cycle. What does that mean? Well, if you get like 6 advisors in a room, you'll probably get 7 opinions. To me, an innovation cycle simply means we have this great opportunity where, yes, led by technology, every single sector of the investable economy is getting improved or changed or going through a new way to invest. I'll give you an example. How many of you know about ChatGPT by now? Yeah. Well, the company that owns ChatGPT is a company called OpenAI. That company might be going public soon. How many of you guys have heard of a gentleman named Elon Musk? Yeah. Well, there's a company called SpaceX. That might be the largest public company when it goes public, possibly later this year. There are many companies that, in spite of all the volatility that we see, want to go public, want to allow you to very easily invest in them for the long term. That does not happen when people are afraid of the future, or when the investment community says, this is not a good time to have a plan to put money to work. That's a way that we think about things to balance what's happening in the world. We also know that historically, if you are just in a disciplined portfolio, in my office I have these big charts that I like to show people, usually because they have big vocabulary words, and I'm not really good at spelling things, so it really makes it easy for me. That highlight that in spite of volatility, a disciplined approach and an investment plan in just a simple, diversified 60-40 model, 60% stocks, 40% bonds. You can ask me questions about international or domestic later. Can return something around 6 to 9% compounding a year. That would be any inflation, that includes any of the worst days in the market. That is something that can build a very comfortable nest egg in retirement while you're still having access to some of the funds as life goes on. Because you do not necessarily account for the unforeseen. It's impossible to. So you want to remove as many unknowns as you can off of the table. One of the biggest joys that we have at Lifestyle Financial, and it does come in great part because of our partnership with Kopenbarger and Kopenbarger, is we take a great priority on generational planning. I'm sure there's some gray hairs somewhere around here, but I do plan on being in these shoes for many decades, and I want to see families grow for 2, 3, 4, 5 generations. We have many clients that we work with. So we start with one generation. We have the privilege to now work with kids and grandkids and great-grandkids, or maybe parents as they get older, grandparents who just want an extra set of eyes or a trusted source of an opinion. That is one of the things that we try to take the best pride in demonstrating, that we have a great fortitude in helping people understand. And if you have a good plan somewhere else, we will tell you. Again, I said earlier, I won't speak ill of anybody else in this field. I meant that. You always just want to make sure, worst case scenario, you have a good plan somewhere else, and you have a trusted gut check every now and then. You need to go see your estate planning attorney once every 5 years because the legal landscape changes so quickly. Well, I can tell you, financial planning changes a lot quicker than that. And what we try to do in every meeting is we try to become teachers. My mom always says I would have made a great 3rd grade teacher because I have the mind of a child. But also I think I like to try to educate people along the way. It also makes it so that I like to think people on the other side of the table get confidence in what I'm saying makes sense to them, can help them with their decision making, and then that instills the value for them to want to come back for more. So before I wrap up, thank you guys so much for the time. Anyone here gets a free consultation with Lifestyle Financial as well. If there's 1 or 2 quick questions before I go, I'll take them now.
Are you a fiduciary?
That's a great question. So, show of hands, who thinks a CFP is a fiduciary?
I do understand.
Yeah, the gentleman asked if I was a fiduciary, which is a great question.
Yeah, what's the difference?
Yeah.
Trustee and a fiduciary.
Well,
Are they
so
the same thing?
So that is, a trustee is a legal term. I'll say it as a non-lawyer will make someone a fiduciary probably to the trust, but you should talk to an attorney about that. The question of being a fiduciary, the only people by law who are fiduciaries are actually called something. Professional fiduciaries. Not licensed financial advisors, not CFA, certified financial analysts, or certified financial planners, CFPs. That does not make them fiduciaries. Now, what financial advisors do get to do, but they don't be transparent about, which sometimes just doesn't come up, is when you have an advisor who charges you a fee for service, a managed account, that by law makes them a fiduciary to that account. A brokerage account, it does not. But no advisor, no certified plan professional is a fiduciary. The only people who are guaranteed to be fiduciaries are professional fiduciaries or trustees. Does that answer your question?
Yeah.
Yeah. One more question? How's that good? Sweet. All right, thank you so much. I look forward to seeing you guys at the break. I'm going to now bring up Chris Carroll to follow up. Thank you.
Good morning.
Good morning.
That was pretty good. Especially for what? Hour and 15 minutes in? That's pretty good. All right. Today I have the pleasure of speaking to you about our Access membership program. Before I get started, I'll let you all flip to the page. And by show of hands, how many of you are clients of the Kopenbarger Law Firm? Can you hold them high, please? Thank you. Quite a few. How many are Access members? Awesome. If you've been an Access member for more than 3 years, keep your hand up for me. How about 5 years? 10 years? 15 years? Let's go 25 years. Pretty incredible. That's awesome. Thank you very much for your support over the years. the Access Membership Program is something that was designed many, many years ago. And as long as I've been at the firm, which is almost 16 years now, it's been something that I wanted to continue to expand upon. And finally, this last year, right at the end and beginning of this year, we were able to do just that. And so this morning, I'm going to go ahead and explain what that program is, what the changes are, and how it impacts existing Access members. Now, if you're not an existing Access member, this isn't your time to sleep, because there is some information that might be relevant for you or your family. But if you are an Access member, definitely make sure you listen up. If there are any questions, though, we do have a table at the back at the break. I will be there. I'm there to answer your questions. I've got some good handouts and some other things to explain what we're going to talk about. All right, so the Access Membership Program is about protecting families, preserving legacies, and providing peace of mind. If you had to kind of sum up the firm's almost 50-year history into just a couple of numbers, this is the best we could probably do. We were established back in '79. Like I said, we're coming up on 50 years. We've served over 43,000 clients across the state of California and throughout their moves here, there, and everywhere across the country and the world. We have about 2,500 Access members, and that was the cap for many, many years. For those of you who have been Access members for a long time, you'll remember it was always maxed out at 2,500 members. We are expanding that a little bit, and I'll talk about that in just a minute. And over 500 years of combined experience, legal experience in the firm. And that number continues to grow as well. Lloyd's a big help to that. All right. So the Access Membership Program has always been designed to give comprehensive legal support for every stage of life. So it's designed to build with you and your family's needs as you grow and as your family grows. It's always been designed to offer multi-generational protection where we're working with kids and grandkids and great-grandkids. And we're very, very honored to be working with 4 generations of many, many clients now. And there were always exclusive things that only Access members would receive. So the Access membership, right now, the way that it works is it used to be $300, now it's a $400 annual estate planning credit every single year, so we just added to that credit. So if you're an Access member and you signed up 20 years ago or 3 years ago or even a year ago, that number was $100 less. Now we've increased that. All right, we've now added ways for you to transfer upon your death or during your lifetime, depending on the tier that you're in, to your children. There are 2 hours of attorney consultation time that are done at no cost every single year. We've kept no additional costs for health or for house or hospital calls, nursing home visits. This is a big one. One of the most difficult things as people get older is they end up in a nursing home or a care facility or even at their home, but they can't travel to and from. Access members, we will come to you no matter where you are in the state at no extra cost and make sure that you are protected and you're getting all the services that you need. There's unlimited estate planning questions and answers by phone and 24/7 online access to healthcare's powers of attorney, and that's going to be expanding as well. So what did we do? We changed the program by adding 3 tiers now. So rather than it being one program, which is what it always was before, now we have 3 different tiers of the program. And there is a foundation tier, a heritage tier, and a legacy tier. The legacy tier offers more than the heritage more than the foundation. Okay. Now, not every single person needs the legacy tier. Not every single person needs the heritage tier. Right? There's different relevant things within each tier. That I couldn't possibly go through all of the things here, but I've got a giant board in the back, if anybody was wondering what that big poster board was, that explains everything. There's also some handouts and some brochures that I've got that'll explain it as well. But some of the things that have changed is what happened to the people who were Access members before. And the answer is all of them were brought into the foundation tier automatically. Now, we've heard some grumblings about it, and they're like, well, wait a minute, how come I don't get legacy tier? Not everybody needs legacy tier, okay? And here's the thing that all Access members should be very happy about. Every single benefit that you had before, you have now, and many of them have increased. And we are asking nothing more of you other than your continued support and working with us. So you don't have to pay any more money. There's no monthly fees. There's no additional fees you have to pay. You guys paid into a lifetime program, and it is just that. It will remain a lifetime program. You all are grandfathered into the previous program. You just get more benefits without any changes, all right? So I can explain all those. I've got a great chart in the back that says what you used to get and what you get now for nothing else. So all the Access members, raise your hands again. Pat yourself on the back for making a good decision. All right, you've got more benefits now than you had before. You don't owe anything. You don't have to pay anything. All right, for people who were not Access members before and didn't buy into the lifetime membership before, the way that it works now is there is an initiation fee and then there is a monthly fee. The initiation and the monthly fee both change based off of which tier you choose. All right, and it goes higher as you go up in the tiers. Now, why would we do that? When we started the firm, it was mainly an estate planning law firm. For those who have been with us for 25 years, 30 years, 35 years, pretty much all we did was estate planning. As the firm has grown, so has the service areas. So now we have estate planning, we have estate administration, there's probate, conservatorship, guardianship, there is contested litigation for estates, there is business and tax, there's advanced planning for high net worth and ultra high net worth families, up to $750 million estates. So there's a lot of different services that we didn't offer before, and we wanted to make sure that those who needed access to those different service areas would be able to do that, but we couldn't do it at the same price point because those other services cost more money. All right? So legacy tier, people who that's really relevant for, if you have multiple pieces of real estate, if you have business entities, if you have a lot of kids or grandkids that you want to bring into the program, that's the people who would be looking at the legacy tier. It's not appropriate for everybody. In fact, I'd say most people it's not appropriate for. The heritage and the foundation, however, there's some good options there. All right? Oh, good. Answered it. Let's put it on speakerphone. All right. So I will be at the back to answer questions about those different things. But again, if you are an existing Access member, all of your benefits are still there or have gotten better. You don't have to pay anything extra. You don't have to do anything extra. Now, what if you're an existing Access member and you say, okay, I love that I have $400 instead of $300. I love that I get access to this. I love that I get new forms, all that stuff. What if I want to move to the next tier? If you want to move to the next tier and it is appropriate for you and we have that conversation, you say, yes, I want to do that, you would only have to pay the difference between what we are now, what the foundation tier now costs and what the higher tier costs. So even if you bought the Access program back in 1992, we're going to credit you for the full amount of what that value is today. Not what you originally paid. So you get a lot more value there. So if you choose to move up, there are benefits there as well. All right? There is limited enrollment. So as I said before, originally when we launched the program, we maxed the number of Access members to 2,500 clients. Why did we do that? The level of attention that Access members get and that they require is a lot higher. The number of attorney hours, if you think about it, if we've got 2,500 Access members and they each get 2 hours a year of attorney time, that's 5,000 hours of attorney time I have to dedicate just to Access members every single year, right? And that's assuming they don't need more than that. And so we had to cap it at 2,500 back when the firm was a little bit smaller. We are now able to double that number due to the number of attorneys that we have. So we are maxing the number of Access members moving forward at 5,000. All right. Now, that seems like a lot. You're like, wow, it's 5,000. But we do have 43,000 clients right now. And so we are having these conversations. We're sending out letters. So if you see that, that's what it is. If you have more questions about it, feel free to talk to me. I'll be at the back by that giant poster board that reminds you of elementary school projects. And I'll be happy to answer any questions for you. All right, so again, if you want to join, you can come back there. There's 3 different tiers. If you want to talk to me about adding your children or your grandchildren to your membership and what kind of discounts are available for doing that, that's an option that we didn't have before as well. All right, so we are getting ready for a break. All right, during the break, we've got a few different tables. We've got the Pacific Justice Institute table in the back. We have the Lifestyle Financial table in the back. We have myself, I'll be at the Access membership table. And outside, If you want to schedule an appointment or a meeting with one of the attorneys, you can do it there. It's also a great time to let us know how we're doing on the green sheets. On the green sheets, at the very bottom of your pile down there, that's where you can let us know how we did today, if we've covered the different topics so far that you wanted us to cover, or if there's additional topics that you want us to add for our next seminar, or maybe do a webinar on if you have more specific questions. The different attorneys and financial planner will be available as well for questions. Don't let them hide from you. If you see them standing in the corner and you have questions, you go pull them out. You make sure that they talk to you during the break. All right, restroom is there, pastries and coffees over there as well. Again, thank you so much. We'll see you after the break.
Protecting some people out there. If you want, you can walk in front of the screen.
Yeah.
All right.
Everybody, we'll get up and do a few jumping jacks. I'm kidding.
Right. So just I need you back up here. And here you go, Mark.
Thank you, sir. I want to give a big thanks to David. He orchestrates all the details of this. Does a great job. Let me push my start button because David said that I have no more than 2 hours, and I promised I would speak for only 90 minutes. I'm kidding you. All right, I'm going to use this because it is something that will keep me on track, so forgive me for reading. I always want to say thank you to the Kopenbarger team because they're amazing. They're my personal estate planners as well as our founder, Brad Dacus. Any of you know Brad Dacus, Pacific Justice Institute? Okay, I'll just say this guy's amazing. Been doing this for 29 years, freely, started with one attorney in Sacramento, but freely defending religious liberty, parental rights, healthcare freedom, keeping men out of women's safe spaces. It's an amazing ministry. And I will just say this to you. How many of you have seen the word free and the word attorney in one sentence often? Anybody? Okay, this is what we do. We defend all of that for free. And Brad will also speak at a church or a synagogue freely and with no love offering, no honorarium. I want to tell you, okay, you come to Kopenbarger like I do. There's a problem in your life. And for me, it was about 20 years ago. I heard Mr. Lloyd Kopenbarger speak. And I realized that we did not have our affairs in order. My wife and I were newlyweds. We've been married a little over 34 years. And we were just starting our family. And we saw that we didn't have things protected for our estate, our kids, guardianship issues, medical issues, asset issues. Okay, so that drove us, that sense of something's a problem, drove us to get a trust. And we've been nothing but happy. And I will tell you, I've been a trustee 3 times and done trust administration. How many of you ever been a trustee? Anybody been a trustee? Okay, it's fun. It's like taking an ice pick and putting it in your ear. But I'll say this, that when you have someone like Kopenbarger to work with you, it's great. I mean, working directly with them took about a year in the process, didn't have to go through probate, totally worth it. You know you're in the right place. Okay, I want to tell you, what we're doing is saying, we're here to protect you and your family and your liberty and your church and your business, and to do it freely. I want to read the mission here for you. First, let me ask you this. Could you want to identify the problem? Do any of you feel that your liberty or property rights are under attack? Anybody? Religious liberty, parental rights, healthcare freedom. Anybody feel that that's under attack? Okay. So now, we want to give you a solution for that if you ever need the attorney in your pocket, that's us and we're free, okay, on these issues that I've mentioned to you. I'm going to give you some real life situations. Think about this with me. Okay, so the first one is your employer tells you, you've done a great job here at work, but if you don't get the vax, you're fired. Have you known people like that? I have. Okay, we've defended no other legal firm, nonprofit legal firm has defended those, but we have, and we've done it, we do it freely. Now, it's not about being pro-vax or anti-vax, it's about you having the choice to decide about your health care. Okay, second thing, and these are all real examples. Imagine you're a public school teacher. Both my parents were public school teachers, I taught school, and I want you to imagine that you are told by your administration, we're going to do some education quietly behind the scenes with these children. Pronoun use is going to change. We're going to teach them about LGBT. We're going to have 2 separate CUME records. I'm Mark, but my CUME record at school is going to be Marlene. Okay, true cases. And you as a teacher have to lie about it to parents. Okay, where do you go? Go to Pacific Justice Institute. We'll defend you freely. We will get that straightened out and squared away. Okay, next one. Imagine that you own a small, let's just say, now I'm going to just start the story and then you can finish it. Okay. Have any of you heard of the Olympus Spa case? Anybody heard of Olympus Spa in the news? Okay, Olympus Spa, it's a Christian, women-only Korean traditional spa. Women only in Seattle. What happened next? Anybody? Okay, a guy wants to come in. They said, you know what? Have you had the transition surgery? If you have, we're going to accommodate you, but he hadn't. So he wants to come in to this women-only safe space in all of his male glory. So now that's being fought in Washington. So we're fighting that. In the Ninth Circuit, it's probably going to go to Supreme Court this year. Okay, last one, I'll say this. Imagine you have children, I'd say, or grandchildren, but imagine you have children in public school, and you put on your social media something like this. We go to, B'nai B'rith something. You go to a certain synagogue, or you go to Calvary Chapel Church. That's all you put. You didn't put, we hate anybody, there's nothing provocative in what you said. And you get a call from a Child Protective Services person, and they say, we've seen your posts on social media, and we need to come and interview you because you're not allowing your children to learn about LGBT. You are just teaching them biblical worldview. Okay. So we will defend those, but we say it's important for people to know in the area of the COVID and healthcare freedom, in the area of this with parental rights, you need to contact us before a social worker comes to your home and says, oh, we're going to pull kids out. They're doing this. Now, you guys may know this. Not a fear tactic. This is in California, in Idaho, and other places, states you wouldn't expect, pulling kids out. So we can stand in front of you and protect you. So I hope that gives you just a little flavor. And we do a lot more, too. Bear with me. True cases, I'm trying to think what they're called, asylum cases, true asylum cases. So how many of you have a fire extinguisher in your kitchen? Anybody? Fire extinguisher, fire blanket, anybody? Okay, you hope you never have to use it, but you want to know it's there. That's what we are. We're here to defend your liberty, your property, your business, to do it freely in the case areas I've mentioned. Okay, how are we different, just so you know? Pacific Justice is different, and there are a lot of great firms out there. And you'll know the names of some of them. You can think of them. They do great work. We work with them. We love them. Almost every firm I can think of, I can name for you. Nonprofit legal firm. They start at the top down. They're looking for Supreme Court cases and federal appellate cases. We're working on the local level. No one was taking COVID cases to help people keep their jobs or be able to go to university. We were. Okay. No one was taking cases to keep social workers out of people's homes and keep them from confiscating kids. We were, so we work at the local level, and then the cases go up from there. We work locally. We're totally no charge. We have offices now in 37 cities, and all the office space actually is donated. So that's a great thing because that means that our founder, Brad Dacus, negotiates and gets free office space and free media. So anybody who's contributing anything, it doesn't go to overhead. It doesn't go to those things. It goes to getting attorneys in the field. Okay, I want to give you some websites as I wrap up here. I'm going to take about 3 more minutes. PJI.org. If you look at that website, PJI.org. And there's a lot of great stuff on there. There's media, if you want to be encouraged with legal victories, the stuff that's going on, that's exciting and good news, legal and judicial victories. TV, cable, radio, there's all kinds of syndicated programs. If you want to be encouraged, I just say this, God is at work across the country. There's Get Help if people have a legal issue they want to have reviewed, or even attorneys in practice areas that we don't cover directly, like family law, contract law, real estate law. We have affiliated, solid attorneys of character and competence. Also, there's Get Help, free resources, and then what we want to do is help people protect their religious liberty, parental rights, the churches. We do bylaw reviews, we do security reviews. Everything we do in Touch is free. Business leaders, what they can do to advance their faith in the workplace, etc. Homeschool co-ops. I want to call up a couple of action points. One is this. First of all, pray for us. We have over 30 attorneys, 125 cases all across the country in active litigation, and many times that being addressed by demand letters. So we're trying to keep costs low, remain effective and efficient, and have a big impact. Cases in every state. Pray for us. We appreciate it. We need your prayers for our attorneys. Second thing is, there's a sign-up sheet here, and it should be in your packet or on your table. Please sign up. If you don't get our updates, it's called Legal Insider. It's just 1 page per month. It's great stuff. You don't hear it other places, but please sign up for that. And we would love to stay in touch. My business cards are back there. We have a table right in the back. It's kind of got the blue drape. But come back and see me. Ask me questions. Olympus Spa, what's going on? We're working from the ground level up. I'll just say this. I don't know if I mentioned this. Did I mention it? Our 4 kids, I have 4 college-age kids. Pray for us, please. And budget-wise and every-wise. Okay. But I just say this, and for wisdom. All of them were told you can't go to university unless you get the vax. We worked with the staff at Pacific Justice, wrote a 1-page exemption letter that went to the university. They became the 5% of university students who attended university without a vax. We just want to help people to get what they want, what they want to do. Protect your liberty, protect your family. You're here, and I close with this. To protect your assets, to protect your family, protect your estate, etc. That's a great thing. We've been Cope & Barker clients for nearly 20 years, and our founder, Brad Dacus, is also a Cope & Barker client and has had Brad as his estate planning attorney for 20 years. I would just say this. What is the asset? What is your estate worth if you don't have liberty? We've got to fight for liberty together and protect your rights. I'd be glad to answer questions, and thank you so much. Yeah. Thanks, Mark. Thanks. Oh boy, now it's time to slow it down. I'm going to slow it down. Let's see. Who am I? Where am I? I need glasses. My name is James, by the way. I'm one of the attorneys at Cope & Barker, and I help people when things don't go the way they plan. Let's go through these slides. There we are. All right. So, administration of trusts. But I better slow down because I won't slow down. This is, and again, we're gonna kind of focus on trust, but think about it from a standpoint of an estate. And I always like to start off this way. An administration of an estate is really what happens when life circumstances come into effect, right? If you have a trust and the trust matures, that means somebody's either become incapacitated or passed away. And if you don't have a trust, a will, then if something happens, somebody passes away, you've got to go through a probate process. And everybody, right? Anytime anybody passes away, if they don't have a trust, they have to go through a probate process. And there's several levels of probate, is what people don't understand. And there's a significant one, where if you have assets and gross assets in excess of a couple $100,000, then you've got to go through the nasty probate that everybody tries to avoid. And then if somebody doesn't have a trust, doesn't have a will, and they become incapacitated, well, there's a process in the probate system for that too, right? Those are conservatorships. Or if somebody is under the age of 18 and their parents passed away and they're inheriting something, well, there's a guardianship. So all of that is an administrative process. And those are the things that my team help, and Matt over there back in the back sitting down is a part of the team. He's up here in the San Jose office. And so everything here, it's really about the process. What happens when somebody passes away? And if you think about it from that perspective, not everybody is calm during that time, right? I mean, we're talking about some pretty stressful situations, and so so emotions are running, and it doesn't matter which of those situations we're talking about. I've got to wait a minute. Wait. Where are they? So I'm supposed to stay over here?
Yeah.
So I've been directed that it's better for me to stay here, and I want a show of hands, right? So a show of hands. If I stand here, can you see me?
Yes.
I said a show of hands. We only had 4 or 5 people. Okay, and if I stand here, can you see me? Okay, I'm going to stand here then. Okay. So from that perspective, right? It's a very, very, very stressful time. Think about it from a standpoint of somebody passing, a family member passing away, or if a family member is becoming incapacitated. Emotions are running high, and everybody's on their nerves, right? And so that's something that's going to happen, and you've got to think through that whole process. Who is going to, right, and I'm jumping ahead a little bit, but think about it from that standpoint, who's going to act, if you're going to pick a family member to help administer or be the person in charge under those circumstances, which one of your kids is going to be, if you're going to pick a child, which one of the kids is going to be the best under those situations? Because I'm telling you, it's not going to be calm. Right? And so you've got to be able to have somebody who can handle that emotion. Everything about, like when you have a trust or a will, everything's about honoring what you wanted to put in place. It really is. And guess what? Sometimes your trustee, depending on who that is, may not want to honor your wishes. So you also have to consider from that perspective, who is going to be willing to honor my wishes, even if they don't like my wishes. All right? My father passed away, last year, January of last year. And his wish, right, from a medical standpoint, was when he got to a certain situation, right, he didn't want to be revived or recover from that and stuff like that. Well, whether that was my wish or not, doesn't matter. Right? He didn't want an elaborate funeral. Now, his family wanted an elaborate funeral, for instance, right? But I went by what my dad wanted. Not what I wanted, not what the other family members wanted. So part of this is also picking people who are going to honor your wishes. And of course, the more you plan ahead, the more it's going to help. So, right? So when we're talking about trusts, and we're going to focus on trust. When we're talking about trust, we're talking about the trustee. And you've learned earlier today what a trustee is. The trustee is basically the person who's in control, in charge. Right? They're the ones who are given the job to do whatever the trust says to do. Put that into play, right? And their roles are to basically follow the trust and follow the law. That's basically the roles. And then of course, while you're living in your trust, right? Because you could become incapacitated and still have a trust and live, you're the beneficiary. But then after your lifetime, who becomes the beneficiary, right? But the trust is going to dictate that. And how, right? The trust may even dictate how they're going to be involved. It's a process. All right, the trustee has control, and now we're getting into the stuff that the trustees or anybody else has to do. So from this perspective, right, what I get is, and I don't get it so much anymore because I guess people just don't call me anymore. Maybe they redirect my phone calls, right?Maybe I have somebody really good, who's working for me that they just kind of redirect them to somebody else. But I used to get phone calls, where it's like, well, Mom died on Wednesday, and we're gonna distribute the trust on Saturday. And of course, that would make the hair on the back of my neck stand up. And so, because there's a whole lot of things to do. And so what are those kinds of things? And this is, some of it's intuitive, right? So like when my father passed away,
He lived in Arroyo Grande, right? San Luis Obispo County. And I live down in Southern California. So I could have driven up to his house every day to get his mail. But what should I have done? Huh? Forward it. Yeah, get it forwarded, right? And that's common knowledge, right? So if he had an automobile and he's no longer driving it, what should I do with the automobile insurance? Cancel it. At least cancel the part on the road, right? Just leave it so if it gets damaged where it's parked, right? And if I sold the house for him, well, what do I do with the homeowner's insurance? Cancel it, right? And if he had a membership or subscriptions, what do I do about those? Cancel them, right? So some of them, it's just like common knowledge. These things aren't so common, right? These aren't so common. So there's some notification requirements that happen. And this, again, happens in probates, conservatorships, but we're talking about trusts. So there are notifications that have to happen, right? So I have to notify the county recorder, right? If there's real estate. And if you think about it, if you and I own a piece of real estate together and I die, how do they know I died? If you try to sell that property and you go to escrow, what's escrow going to say when my name is on the deed? Right? We need James to sign. So what do you got to do? Right? Well, I can't sign anymore, so you got to notify them that I passed away. And then it all depends on how the title is held. Right? Was it held as joint tenants without a survivorship? Tenants in common? Was my part put in a trust? How was it held? And that's going to dictate what happens afterwards, right? So that's the thing with real estate. So if there's a real estate, there's a trust, and there's a trustee on it. My dad's stuff was in the trust, and so as a trustee, we had to notify the county assessor and record an affidavit of the trustee. And for some reason, the county assessor wanted to know too. Well, what happens when somebody passes away and the real estate transfers to somebody else?
It gets reassessed.
Gets reassessed. Yeah, there's a possibility it gets reassessed, right? And so they want to know, and they want to know just because they want to know, right? They're not going to raise taxes or anything, are they? Well, of course they are, right? But that's why they want to know, right? You have to notify beneficiaries or heirs, right? And here's the thing with beneficiaries or heirs. Here's something really interesting with this, is that if there's somebody, let's say somebody has a trust. I doubt any of you have a trust, but let's say one of you did, right? Of course, I'm kidding. Right? So you guys have a trust and you name beneficiaries in that trust. And all those beneficiaries are going to be notified that when a trust or a portion of the trust becomes irrevocable, they got to be notified of that. And they get a right to a copy of the trust, right? And there's reasons for that. Because if I went and a day or 2 days before my dad died, I went and had the trust changed. And I had my dad disinherit my 5 siblings. Right? Do you think the family would be okay with that? No. You don't? Oh, maybe I shouldn't have done that. Well, oh no, but I didn't. Right? But you think about it, and it's like, would that beneficiary then should then that beneficiary have a right to say, well, maybe Dad wasn't in his right mind. That mentally he was unable to. But yet James somehow got him to sign something that said, I knock out all the other 5. Well, absolutely. Right? Or what happens if there's a situation where it's a blended family and one of the spouses of that blended family pass away and the trust or a portion of the trust becomes irrevocable? Well, then in that instance, should the family of the deceased spouse be able to be notified and get a copy of the estate plan to be able to, because who's accountable to that surviving spouse? Right? And it's just like me, right? Who am I accountable if I'm the trustee of my dad's trust and I don't have to send anybody any notice? How do they know? Right? So people have to be notified. Government agencies have to be notified for taxes and other reasons, right? So, long-term care and stuff like that. And so there's notifications that have to go out. His will had to be lodged with the court. Somewhere around 1850, California passed a law that says if you had a will and you were in possession of that will within 30 days of somebody dying, that will had to go into court. Why is that? prevents people from tearing up the will and not having to probate. But it's basically to get the will into court, so it has to be probated. So if you've got a trust and there's a will with the trust, it's got to be sent into the probate department. Got to get a tax ID number. What happens to my social security number when I die? Yeah, it's no longer valid, right? But yet if I have an estate, right, whether it's probate or a trust, I have an estate, it continues on. The estate continues on. So the taxing authorities want to know, because what happens to the income? If there's income, who gets taxed on it? How does the government get their tax if there's no tax ID number? Right? Well, if you're the trustee, think about it. If you're the trustee, do you want your social security number on there? Because you're going to be responsible for the taxes on everything in there, even though you have 5 siblings. I don't want that responsibility, so the trust, the estate, becomes a separate taxpayer. All right? And then trustees have duties. Right? So, and that's not the full list. That's just the ones we wanted to put up. All right, so the first one up there, and we're going to go through this, and each one of these is going to take about 20 minutes. We're going to go through each one of them. And so somewhere around 2:30 or 3, after Mark gets back up for his second time, you'll be out by 4. And no lunch is being served, and the restrooms are going to be closed in about 5 minutes. So the duty to administer the trust, right? This is very basic, but it's hard for people to comply with. You know what that means? The trustee has to do what the trust says to do. What's written in it? They can't deviate from it. How many times do I get a situation where a child is living with parent towards the end of parent's life, and there's 4 other kids, so there's a family of 5, and one child is living with parent, and the trust says that upon the parent's death, everything gets distributed equally, to all of the siblings, right? To all of them. And the trustee is, well, I'm going to just let them stay there. That's not what the trust says. The trust violating the first part. They're not doing what the trust says to do. The trust says you can't let the person live there. You got to evict them. Get them out. That's kind of harsh, but that's what the trust says to do. Because if mom or dad, whoever the surviving parent was, wanted the child to be there, this is the court's perspective on it, if they wanted the child to be there, then they would have changed their trust to say my child could live there for a certain period of time. And that period of time could be for the remainder of that child's lifetime. But they didn't. So since they didn't, that's not what they wanted. They wanted everything to be liquidated. They wanted everything to be distributed. They wanted that child out of the house. Otherwise, they would have put it in writing. That's the perspective. And so if you have a situation like that, you got to make an appointment because you've got to change your trust. So, duty of loyalty. If I'm the trustee and you guys were all the beneficiaries of my dad's trust, who am I supposed to be loyal to? Myself, right? Do what's in my best interest, right? Be selfish, right? No. Trustee is a selfless job. Yeah, you're looking out for the best interest of everybody else. So everything I do has to be in your best interest, right? So if one of the beneficiaries over here sues, right, to say they wanted more, because I've never seen anybody sue to get less. Never seen it. All right? So they sue to get more. I have to decide, well, do I spend the $200,000 or $300,000 it's going to take to defend that lawsuit, even though they're not supposed to get more, even though the trust is absolutely clear that they're not supposed to get more, but they still sue, or do I settle and give them a little more? Because what's in your best interest? If I can settle for $50,000, but it's going to cost me $200,000 or $3,000, what's in your best interest under that circumstance? Even though it's going to be against my better choice. I mean, if it was me, I might just defend it and spend the money, but it's not my money. It's your money that I'm trying to preserve. So even though they're wrong, it may be in the best interest of all of you to settle that and give them a little bit more money. I'm not saying it would be, but it could be. right? So everything has to be considered on an individual basis. Deal impartially with beneficiaries. What does that mean? I'll tell you what it means since you weren't so quick, right? It means I can't favor anybody. So if I'm sorry, right, well, let's not even say I'm sorry. I'll hit a couple of them here at the same time. I'm the trustee and I was living with Mom. And Mom died and the trust says it goes equally to the all 6 of us kids. There are 6 in my family. Right? And I decide that I'm going to live there, continue to live there until I have enough money to move out. Am I treating all the beneficiaries equally? No. Am I being partial to one of the beneficiaries? I am, right? And which is also avoid conflict of interest, the one below, by the way, right?
Jay, on that same point, to your previous point where you were going to give someone an extra 50, seems like those 2 points you made are in...
Yeah, but they're not. And he says basically the 2 points are in conflict where I settled a lawsuit with somebody for $150,000 less than it would have been if I take it all to trial. So I understand what you're saying, but it's still not a conflict. But yes, it could appear to be one. But if all I did was give that person an additional $50,000, without there being a lawsuit filed, now I'm treating them impartially. Right? There's impartial treatment there. I got a duty to take control and preserve trust property. When my dad died, I had to get my name on all the accounts. That's taking control. Right? It doesn't mean like I'm taking, I'm taking it as my own, but I have to get control. If I don't have my name on the bank account, the investment account, the real property, the business interest, whatever there is in the estate, I'm not taking control of it. And I have an obligation to take control of the property. We're going to skip the next one. Enforce claims, defend actions. I think those are self-explanatory. Not to delegate to others. So one of the main rules in a trust is the rules of the trust. In other words, what makes it operate? The trustee's instructions are written into the trust. And if the instructions are not written into the trust, then it's what does the state's probate code read on those particular powers that they want to do. And if the trust is silent and there's no a negative, right? No prohibition in the code, then there's a question as to whether the trustee can do it or not, right? And so that's one of the interests. But here, right, a duty to delegate, it says in the law, in California law, it says a trustee cannot delegate any duties. But a trust, they say a trustee can delegate duties. So which one does the trustee have to follow? Remember, I put the hierarchy. Hierarchy is trust first. So if the trust allows the delegation, then even though the California Probate Code says, right, because the code says if the trust is silent, these things come into play. Right? So everything you have written in your trust is what controls the trust. And so when you have a trust, and I've seen these, I've seen a trust written on a sheet of paper, one sheet of paper. One sheet of paper. I can write a trust for you, anyone in here, on a Post-it note. I can write a trust for you and have it on a Post-it note. And it's still a trust. Right? So don't be concerned or don't be confused about a trust has to be something that's multiple pages. It doesn't. I can have a written trust for you on a Post-it note. A little, so long as I can get all of the elements of the trust on there. And so from that perspective, if there's a trust like that, then you have to rely on what's in the California Code. But if you have a comprehensive trust with all of the authorities and powers written into it, then that's the owner's manual, right? Those are the instructions. That's what makes it operate. That's what possibly keeps it out of court. Because where do attorneys make most of their money? In court. Yeah. So I don't mind, right, going to court for people. I don't. I like to eat, right? So well, you've heard the joke, right, about there's a small town, and there's an attorney in that town, one attorney in that small town, and for years that attorney can't make any money, right? So then another attorney moves in, and both of them are making a whole lot of money. Went past you, huh? You need two attorneys in order to be in conflict, right? To have some conflicts. So, but anyway, co-trustees, I hate them. Can't stand them. I hate two bosses. Anybody here ever work for anyone? Just one or two of you. Anybody here have two bosses at the same time? Right? And if you have, you know what I'm talking about. Co-trustees are like two bosses. Co-trustees is like Congress. How long does it take Congress to do anything? Right? And co-trustees are the same. And it's not that the trustees are bad. But think about it this way. We're going to go, where are we going to go? Okay, we're going to go to Levi Stadium. There we go. We're going to go to Levi Stadium from here. All right? That's our goal. Are we all going to take the same route? So if you're driving, you're saying no. So if you're driving with me, and I start going the route I take normally, what are you going to start thinking inside your head? I'm going the wrong way, right? Yeah. And even or if you don't like the speed I'm going, what are you going to say? Right? Right? Or if I tend to go through yellow lights, what are you going to say? Or if I tend not to go through yellow lights, what are you going to say? Okay? Or if I tend to go the speed limit on the freeway, what are you going to say? Right? So some of you may have heard of my car. I have a car. It's a trustee car. And it's a situation where let's say there's 3 trustees. It could work with 2, and it could work with 4, but let's say there's 3 trustees. This trustee car has 3 steering wheels, 3 gear shifts, 3 brake pedals, and 3 accelerators. The car is backed in right over here. How long is it going to take us 3 trustees to get out of the parking lot? Right? How long is it going to take the 3 of us? And now think about it. And all of us have to be in control. All of us, as trustees, have to be in control. How long is it going to take us to get out of the parking space? Right? So either, what has to happen in that scenario? Think about it. What has to happen in that scenario for that to work? Either all 3 trustees have to work in unison, right? They all have to work together, the same goal, the same plan, everything, or 2 of them have to throw up their hands and say, I give up, you do it all. Right? And mom and dad, typically, if it's kids as trustees, they're saying, well, I don't want to, when they're setting up their trust, they're saying, I don't want to hurt anybody's feelings if I don't put them all together. Whose feelings are being hurt when you do? And the one that's going to do all the work anyway has to have those 2 saps with them. Right? Right? Think about it. Think about it. And let's think about this too. Most of us, when we think about our planning, think about this planning is all about when I die. You've got 3 trustees trying to take care of you while you're living and incompetent. How's that going to work? I hate post-trustees. I hate more than one boss. Now, you have to remember, you're the boss when you set up your trust. Right? I have to do and follow if I'm a trustee, and if I'm a lawyer, I have to do and follow what you say. But I'm telling you up front, I hate them. Can't stand co-trustees. And that's what I got to say about that. And you might think now of what I think about trustees. Duty to comply, duty of diversity, no, duty to, okay, the next two, the general to report information, and duty to account. Those are kind of the same things. So I'm a trustee, you guys are the beneficiaries, right? My dad died a year ago, and now I'm ready to make distributions. I'm going to write you guys out a check. Each one of you is going to get a check, and you know nothing else, right? Because I haven't been informing you throughout the entire year. I'm going to write you a check, and you're going to be okay with it, right?
No.
I'm going to write you a check from the no.
No.
You don't trust me?
No.
Well, was it because I bought the new car 4 months ago? Was it because I took the family on a nice vacation 6 months ago? Right? Why is it? Right? It's because I haven't been talking to you. I haven't been informing you. You don't know what's going on. And even though I'm a very likable person, maybe, right? But even if I was, and even if I was the most honest person around, and I didn't communicate with you, you'd still be thinking good thoughts about me, right? You wouldn't be thinking bad thoughts. You wouldn't be thinking, what's he doing with the money? Right? How come he went on a vacation? Why did he buy that car? Yeah, and you'd be thinking I'd be spending my own money, right? Not the trust money. No, of course not. You'd be thinking of spending the trust money. Why? Because that's the way we are. And so this is just something where the trustee is required to keep you informed. Doing something that they should be doing all along. Because communication is the key to the relationship, is it not? It absolutely is. It's a key to the relationship. And so I've got to continually keep informing you, keep thinking, letting you know what's going on. And one of them is just a general duty for me to keep you informed. Hey, we're going to sell the house pretty soon. Hey, we're going to do this. And hey, I'm doing this. And hey, you're going to get, the lawyers are going to be doing these things, and you're going to be getting all these things in the mail. And hey, just the duty to account, though, is a fiduciary report of the finances. And basically, it's more than an income and expense report, but more than anything else, it's just financial. It's a legal document, really, that gets sent to the courts. That's what the real reason it gets prepared is because we're going to go into the courts because one of the beneficiaries isn't going to like what we do, right? And so if a beneficiary doesn't like what we do, then we may end up being in court, and that account is something that California, every court in California can look at it and understand it because they're the ones who set it up. Think about it this way. Everyone in here somehow, some way, manages their finances. Do you think you'd do it all the same? How many people here keep check registers still? All right, a good amount. How many pay their bills online? Right? And how many balance checkbooks? Right? It's not everybody. So if everybody have their different methods of reporting income, and all of those different methods go to you because you're the judge, you got to figure out everybody's method. Right? So this account is one, not universal, statewide method of reporting what happens in a trust. The sales, the losses, the gains, losses, all of those kinds of things that go on. So that's why it's there. And the trustee's required to do it. I'm the trustee, you guys are the beneficiaries. Only you can tell me I don't have to. Right? And so the question is then, if I'm the trustee and you're the beneficiaries, are you going to want me to financially or in writing report to you of all the financial transactions? No?
Yes.
Of course you are. Well, of course you won't, because you trust me. How many trust me now? No hands. Wow. So, got an elbow over here. All right? So that's the job of the trustee.
So I've got a question. So typically, administering a estate is a once or twice in a lifetime, and no experience for the executor. So how much support does that executor need to know that they're doing taking all the correct steps.
Like as far as the involvement from
Yeah, just to avoid overlooking a required step. I mean, so first thing I would tell my heirs is go talk to you guys.
Yeah. So basically, well, when somebody comes into our office, and this is one of the things I tell everybody, even if they don't come and see us, go see a lawyer. Go see a lawyer. Because if you as a trustee do something wrong or fail to do something, you're going to be personally liable. Now, but if you go see a lawyer and that lawyer is telling you to do something or telling you you don't have to do something, even though you're still liable, it also now creates a situation where that attorney could have committed malpractice, right? Because they didn't tell you everything that needed to be done. And not all lawyers do this, by the way. Not all lawyers are this thorough. You know, Matt and I have seen situations where lawyers, they just skim over some of this stuff, leaving the trustees potentially exposed. I don't know where a problem may come up. If I had a crystal ball to see where the problems come up, then I wouldn't have to have a trustee. I wouldn't be suggesting the trustee do all of these things, because some of them I'm going to know there's not going to be a problem in. I just don't know where the problem's going to show up. And it's no different than the trust you created through this firm. It's the same thing. You say, well, my goodness, James, that trust is like 100 pages or something like that, or 50 pages. Why does it need to be so big? Well, because those are supposed to try to avoid problems, and I just don't know which problem you're going to have. So and that's why they're so big. And so part of it is, yes, go see someone. Get the advice, get the direction, and stick with them. And it's even at the end of the administration. It's like, sometimes the beneficiaries don't want to release a trustee. Now, I know everybody here would release me, right, of liability. Because when I give you that final distribution check, you have 3 years. The law says you have 3 years to sue me for something I may have done wrong during the administration. Well, I want you to release me now. Well, if I don't give you a financial record of what's happened through the administration, are you going to want to release me? If I'm not keeping you informed of everything going on, are you going to want to release me? No. So, everything we're talking about is really me as a trustee wanting to be able to sleep at night because I'm not concerned about you guys, coming back and suing me. Because remember, I'm your sibling and I was the favorite. Right? And you know how you feel about those favorite siblings. The mom and dad's favorite, right? And I was a favorite child. And I could do nothing wrong, right? You've never seen me do anything wrong, right? No, but mom and dad, they never saw me do anything wrong. But you never saw anything wrong. No, of course, you saw everything I did wrong. And in fact, I might have been the instigator of it all. Right? And caused you to be the one get into this trouble. So you're going to release me, right? No. Right? So part of it is, I've got to keep you informed. I've got to keep you, I've got to give you all the information in order for you to make an informed decision. Discretionary powers. Right? So sometimes the trust, there's written in the trust that says the trustee has sole and absolute discretion to do X, whatever the X is. Make distributions or whatever. Had a situation one time where somebody was living, one of those situations where someone was living in a house against the rules of the trust. The trust just said distribute it to the 5 beneficiaries, and somebody was living there. The trustee allowed the person to live there. And the trustee said, well, I have sole and absolute discretion. You know what sole and absolute discretion is? Any of you have kids? Couple? 1, 2? Any of you have, and at one time, any of you have parents? 1 or 2 of you. Again, same couple of you. All right, so from that standpoint, you've probably, and nobody in this room has heard it. I know this because if you have kids, you're fantastic parents and you never said this. And if you're a child of parents, you probably never heard it from them because they were fantastic parents. But if mom says do this, and child says, why? What's mom's reaction?
Because I said so.
Because I said so. That's sole and absolute discretion, right? A trustee can never say to the beneficiaries, because I said so. It could be because the trust says so, or the law says so, but the trustee can never say, because I said so. All of the trustees' sole and absolute discretion has to be carried out reasonably, with reasonableness. And that's one of those, vague legal terms that who knows what reasonable means, right? But it does. It's got to be carried out reasonable. And so trustees may have discretion, right? Discretionary powers, sole and absolute, but it's got to still be exercised reasonably and exercised within the instructions of the instrument there, the trust. And then the last one there is the general powers or the general duties. And to me, I look at that one as being, as trustee, I have to do unto you as I'd want you to do unto me. All right? That's the way I look at that one. Here's some of the things trustees have to do. I'm going to do it on time. We've got a few minutes. Pay debts, set distributions, timings, conditions, and all that other stuff. They got to track income. This is all a part of the information that I want to be providing to you, right? Because I got to track all these things. I got to pay income taxes. I've got to pay income taxes on my dad's, his personal returns for the trust. I got, all these taxes have to be paid, and then you've got to pay taxes on the income that's produced out of the trust. So the trustees have a lot to do. Defending legacies is when either the trustee is not doing what they're supposed to do, or the beneficiaries don't like what the trustee is doing, or the trustee is the favorite child. Because you know how you always want to get at that favorite child, right? And then again, it's just the legal process. Now we're talking about lawsuits, right? Somebody in this administration has filed a lawsuit. And this is whether it's in a probate or a trust, it doesn't matter where it is. We've seen people fighting over who is going to take care of mom and dad in a conservatorship action, right? And so because mom or dad never put down in writing who their preference would be, right? Because again, you've got the 3 kids and they all want to take care of mom or dad and they want to do it in their best interest, but they're going to do it in different ways. So if I was over here mopping the floor, how many of you would say, you're not doing it right? So most of you might say, look, you're mopping the floor, go ahead and do it. I don't care how you do it, right? But some of you are going to go, you're not doing it right, right? You got to go north and south, not east and west. You got to mop at a diagonal, right? I don't know, you got to do circles, right? All of these different, you're doing it wrong. Do it this way. And so those kinds of battles happen. So it's a legal process, and then it's used when basically they can't be resolved on its own, right? Because think about it, when you were a child, and if you have a sibling, and if you didn't have a sibling and you fought with yourself, you need a whole lot more help than we can help you with. But if you had a sibling and you fought with that sibling, who is the referee? Who broke up the fight? Right? Mom or dad? Probably mom. Right? So now when mom or dad's not there, because they passed away, and the adults are older and they're still getting in fights, right? So you still have disagreements. So when that happens, who becomes the referee? The judge. Yeah, that's where the judge comes in. So if you can't resolve it on your own, you got to bring in the judge. Here comes the judge. Right? They're the referees. There's all kinds of reasons why. We recently started an administration where 2 pages are missing. How do you make up 2 pages? I can see how you lose 2 pages, but I mean, how do you, I don't know. Incomplete documents. We don't have everything. Poorly worded. So is anybody here? How many here have heirs? H-E-I-R-S. A hand of how many here have heirs? And this is actually a lesson on how words work, right? None of you have heirs. None of you. And you know how I know? You take these two fingers and put them up here where you can feel a pulse. And if you can feel a pulse, you have no heirs because you're still living. Okay? But yes, tricky. But that's how that relates to poorly worded documents. Because if I don't use the right word, the word I'm using may have a different meaning. Right? So, does anybody know what an issue is? I have an issue with that, right? In the law, especially in the States, an issue is your child. Well, I have issues with them too, right? But my point is, words matter. And if I'm sloppy in drafting your trust and not using the proper words, then that matters. I want my child or I'm married a second time and I want my new spouse to reside in the residence for the remainder of the life estate, for the remainder of their life, and the lawyer puts in there, gives them a life estate. A life estate is a legal term of art, meaning one specific thing. It doesn't mean that they get to live there. It means they take legal ownership of it for the period of their lifetime. But I've seen many, many trusts drafted that says life estate. And so words matter. Poorly worded trusts, right, can cause problems. Because lawyers like Matt and myself will comb through that, right? If a child of yours comes in and says, well, I don't like what this says, and we're going to go, well, let's take a look at it. Let's see how we can pull it apart. Words matter. Greedy children never are a problem, right? I know none of your kids are greedy, but I know some. They're out there. But part of that is sometimes they're just greedy. But part of that is maybe even emotional issues. Sometimes they dig in their heels just because they're not ready for things to be processed. You don't know how many times you see somebody where it's like, well, I don't want the household yet because, sometimes the trustees are that way. But yeah, sometimes the people involved, right? Trustees and fiduciaries, when we represent them, we try to get them or help them do what the trust says to do and help them defend what the trust says to do as well. And the beneficiaries, generally, beneficiaries are suing when a trustee, if it's not because of greed, because they just think they needed more, right? But it's because when the trustee's just not doing their job. We have beneficiaries come to us and say, look, Mom or Dad passed away 4 years ago, and nothing's been done. So are we essentially then filing something because we don't like what the trustee, well, yeah, we don't like what the trustee's doing because they're doing nothing. Right? But if the trustee was doing what they're supposed to be doing, everything we kind of went over, not everything, but everything we went over earlier this past 4 hours, with the things the trustees have to do, and if they're not doing their job, then yeah, we got to go in and try to force them to do their job. Because you wrote a trust that says, when I die, do this. And the trustee's not doing it. They're just not doing it. Your fault for picking the wrong trustee. You're supposed to chuckle. So beneficiaries and we live in an instant culture, right? I mean, and it's been kind of that way. Anybody remember dial-up? Yeah. Ever try to download a picture using dial-up? And remember, I used to get excited when after 2 hours it was like a third of the way downloaded. Anybody remember this time, or is it just me? Or you'd be half a day and it's like, oh, look at that, it's almost all the way loaded. And after 7 or 8 or 9 hours, boom, you get your picture. Oh, look at that, this is so neat. What do you do today when it doesn't load? How long does it take you to get frustrated when that picture doesn't load today? Yeah. How long does it take you? I mean, what do you feel when you can't get coffee within 30 minutes or 30 seconds? A hot cup of coffee, right? Well, what do you do about that? Remember having to percolate coffee? I mean, you're bored, right? Would you be able to wait for that pot to boil right now? Right? What do? Now? You grab a pot, you put it into something, and you get coffee out in about 15 seconds. Right? We live in that culture that we want everything instant. Everything, right away. So, beneficiaries can be impatient. Right? Whose money is it in their mind? Right? As soon as mom and dad passes away, whose money is it? It's mine. Right? And technically it is, but it's still got to go through the trust and stuff like that. They're unthankful, sometimes unthankful, and they want more. And then it's just unresolved issues because I'm the favorite. Trustees, and again, we've gone over these. They're not informing the beneficiaries. They're not competent, right? Because you picked the wrong trustee, right? You pick the person who should have been making medical decisions for you and not the person who should be managing your finances. So they're not the right fit. Or they're actually, we've had situations where the trustees, I'll just borrow the money from the trust and pay it back. How often do you think that happens? Well, I mean, for one, why do they need to borrow it? Why do they need to borrow it in the first place? They should have been financially independent. I mean, not independent, but at least secure enough to not have to borrow it in the first place. So or they're in, the trustee influenced. Like I went and influenced you to do something, right? So again, like my dad, if a couple of days before he died, I went ahead and had him change the trust to disinherit the rest of my siblings, right? Well, I might have unduly influenced them. Right? I might have said, look, I'm going to throw you out in the street. You're going to have to live on the street by yourself unless you do this. Right? Influence, undue influence. So, nasty stuff. Type of cases, proper trustees, asset disputes, investment assets, all of these different things. Removing trustees, or actually inserting trustees. So, when we're in court for a lot of different reasons. Let's see, Matt was doing one right now. Yeah, you're doing something recently. I forget what you're doing. But anyway, the different contract disputes, elder abuse, personal injury, wrongful death, there's all kinds of things our office can help with. I don't do it, right? But there's all kinds of things. And if you have a situation or if you know it's somebody, give us a call. We can probably get you a referral. So, there are many attorneys in here who can help with that. So your estate plan, it says here, it's only as strong as you've updated it. We've got some situations now where if people want their trust to be the beneficiary of IRAs, because in my perspective, everything you have should flow through your trust. Because you've spent the time and energy to create this thing exactly the way you want it. And it has contingencies in it that you don't know about. Like if a child becomes incapacitated, they don't have to give it out to the child. It can stay in the trust, right? There's things inside the trust that you don't know about that we would be able to guide the trustee on, after your lifetime. But if you had that IRA go directly to that child, and they're incapacitated at the time you passed away, well, now we got to go get a conservatorship for that child. Whereas if it stayed in the trust, or if the trust was a beneficiary, the trust can create a trust for it. And so there's all different kinds of things that your trust has in it. Well, if we prepared it, your trust has in it that gives us a bunch of flexibility. But my point is if you're going to have your IRA go to the trust, and your trust is more than a couple of years old, you got to make an appointment. You got to make an appointment because we got to add some language. Because Congress is constantly tweaking with those IRA rules. It's not the IRS, it's Congress. Leave it alone. Do other important things. Who should I refer? What's my answer? Everybody. Even your enemies. Right? I don't care who they are. Refer them. I look at it this way. And we've got, there's all kinds of things we can do. I've spoken at service organizations. I've spoken at groups of real estate agents, just things like that, just people getting in front of them and giving them information, because everything we do has to do with information, giving people information, because information is power, right? And, the more you know, right, the more secure you can be. And so this is really, because you can't make a decision, you cannot make a decision without the information. Right? A good decision. You got to know the pluses and the minuses in order to be able to make the proper decision. So we'll get out in front of just about any kind of crowd in order to give them some of the information they want. And when I'm in front of some real estate agents, I'm not necessarily talking about estate planning. Maybe sometimes probate, but sometimes it's real estate related or something. So it just doesn't, it just depends. But basically anyone. And I look at it this way. And so I'm sure some of you've heard the story, but there was I had somebody come in and see me several years ago, and a child of his passed away, and a motorcycle accident, and the child was 34, 35, somewhere in the mid-30s, and I'm a little animated from time to time, if anybody knows. Okay? And so my conference is, even though I empathize with people and I'm sorry, the people have lost family members and family members have passed away, I interject humor in what I do. And so during the course of this meeting, he's telling me the story, and it's a sad story. And at the end, and we're sharing our thoughts, we're sharing experiences, and we're crying, we're feeling bad, we're laughing. Just all of the different emotions come up. And at the end, he never became a client, because my belief is anybody who sits there is appointed to be there by God. That's my belief. You don't have to believe that. You don't have to believe that, but that's my belief. Is that the person sitting on the other side of that desk for me is appointed to be there by God. And I don't know for what reason. It doesn't have to be because they're going to become a client. I don't know the reason. At the end of our meeting, he got up, we shook hands, we hugged, and he says, "James, I haven't laughed in 4 months." Who's to say that wasn't the reason he was supposed to be there? I don't know. He never became a client. Never spoke to him about that afterwards. So refer anyone. If you think we are the people to handle this, if you think that we will understand their situation, have them come in. They may not become a client. Have them come in. But they're going to get the best we have to offer. And so refer everybody. What does it say about your enemies? Yeah. Right? So refer your enemies. Everybody. They'll decide whether they become a client. You don't have to decide that for them. With that, ladies and gentlemen, we're just about done. The only part, and Amanda's running back to sit down so she can book your appointments. Is a lot of stuff here you've learned today. And I'm not sure there's a single person in here who is able to say there is nothing there that I need to do. There's a whole lot here that we said today. And I think even if you reflect back on your plan and what you have, that almost everyone, if not everyone here, would make an appointment if they're honest with themselves and be able to see. Remember, the appointment's free, right? It just costs your time. That's all it costs. Well, and the $30 of gas it's going to take to get there. We're not reimbursing you for gas. All right, but that's it. Anything else you want? Oh, green sheets. Green sheets. Yeah, those green things. Remember, James equals 10. James equals 10. Anything less than 10, it gets thrown out. Nobody ever sees it. I look at those things first. So, no, go ahead. Those green sheets are important to us. If there's information that you think we should be discussing during any of these periods, if this is only good if it's valuable to you. If it's not valuable to you, we're wasting your time, we're wasting our time. Right? let us know what you want to hear about. Now, granted, if you put something down, we may not add that to the agenda because, a majority of people or a lot of people don't want to hear about that, because, somebody might put down, talk about the Dodgers.
Giant.
No, Dodgers. They said I'm assuming there may be nobody in here who wants to hear about the Dodgers. So I'm just saying, right? So but if even one of you wanted to, I would. No, only kidding. Book an appointment, there's still opportunities. Again, what you're going to bring to any of the appointments, any estate planning documents you have, you're going to fill out some information because your information may have changed. You may have had that bank account with Home Savings and Loan some years back, and it's still listed there on your trust. So, or Washington Mutual. Some of you looking at Home Savings and Loan, what the hell is that? Pardon my Russian. What the heck is that? But Washington Mutual, let's put that one, right? That's more of a recent one that recent meaning, 20 years ago, that changed. And then, of course, the list of questions you have for the attorney. We're just lawyers. That's all that says. I'm not great at marketing and selling ourselves, but we're lawyers, and we've got some pretty qualified ones with us too. So it's not a waste of your time if you come in or when you come in. All the different ways to contact us, the QR codes at the back of everything. Thank you. We're happy to see you. All right. Have a prosperous and peaceful day. Oh man, I'm at 3 minutes. I could have talked for another hour.